All right, greetings everyone. We've got folks coming in and getting in our from the waiting room. We're glad to have you here. Ken Phelps from the Daytona Regional Chamber of Commerce. Welcome everybody to our Real Deal discussions, Emergency Paid Sick Leave and the Family's First Coronavirus Response Act. We're producing these programs in an effort to bring you the best possible information in a time where that information is changing very quickly. So we'll do our best to help get you up to speed on the emergency paid sick leave and what that means to your business. A couple of housekeeping items before we get started. Please mute your microphones if they're not already. This will minimize the background noise so everybody can hear the presentation clearly. If you have a question or a comment, we'd ask that you submit that through the chat function in Zoom. We'll be keeping an eye on that, and we will get to as many questions as we possibly can in the allotted time. If you miss something, we are recording the session, and it will be uploaded to the Daytona Regional Chamber of Commerce website on our COVID-19 resource page, as well as to the Daytona Regional Chamber's YouTube channel. So you'll be able to check those out after the session once those videos are downloaded and converted. So with that, it's my pleasure to welcome and introduce our presenters for today's webinar. Business law attorney Greg Snell of Snell Legal will lead us off. Greg's been assisting business clients, large and small, in the area with employee issues for many years. He's a graduate of Cumberland School of Law at Samford University in Birmingham, Alabama. He was a member of Leadership Daytona Class 10 and is a past recipient of the Marvin Samuels Memorial Leadership Award. Greg will be followed by Larry Bucholz, the HR Director at Vision H.R. Larry has been with the company since 2004. His dual bachelor degrees, one in economics, the other in business administration, as well as an MBA in organizational behavior. With nearly 30 years in the human resource management and employee training field, Larry brings a wealth of knowledge to all human resource related matters. So with that, Greg's going to lead us off, and then Larry's going to take the baton from him partway through. So with that, we'll get right into the conversation. And Greg, you are welcome to take it away.
All right. Well, thank you, Ken, and good morning, everybody. It's great to be with you, even though it's virtual. I can feel your presence. I don't want to ramble here too long, but we mentioned my law school, Cumberland School of Law. That's at Samford University, and of course we skipped the rest of my education. And the reason for that is because Samford University is in Birmingham, Alabama. And for any of you that know Jim Cameron, he has certain ties to Alabama, so he kind of focuses on those Alabama things. Anyway, I'm going to go ahead and just jump right in so that we can get through our basic material, and then we can maybe answer some questions. Obviously, we're here about the Family's First Coronavirus Response Act, which is actually two acts in one. One of them is an expansion of the Family and Medical Leave Act, which I think probably most or all of you are already familiar with, but they've just sort of put it under this one heading of Family First Coronavirus Response Act. As you can see from our slide, it went into effect on March the 18th, so it is in effect now. Well, it was signed into law on the 18th, and it went into effect on the 1st of April. It expires as of now at the end of the year, but obviously we hope we're through it by then, but it is conceivable that it could be extended. If it is, I guess maybe we'll be reconvening for another session to discuss how that, what matters there. Anyway, I did want to mention too here at this point that it's the Wage and Hour Division of the Department of Labor that's charged with enforcing this, and they have indicated that there will be amnesty for enforcement for the first 30 days. So if you messed up and you denied somebody benefits and you figured it out and now you're fixing it, you're good, you're safe through the 17th of this month. So there's still a little, opportunity here to avoid any sort of enforcement action by the Wage and Hour Division. Obviously, as you can see, again, the major components here are the Emergency Expansion of Family Medical Leave Act, which, if you don't know this already, it really just relates to child care. And I'm going to get into that in a little more depth here shortly. But that's all it's about, is really taking care of the children. Then there's the what's also called the Emergency Paid Sick Leave Act, you'll see it referred to, we have it on our slide as PSL, but you'll probably see it referred to in some places as the EPSLA. That is about people who are affected by COVID-19. And so Larry is actually going to cover that portion of the presentation in depth, and I'm going to handle the Emergency Family Medical Leave Act portion of that. There is a tax credit for most payments made under these programs, which is sort of nice. And again, I think Larry's probably going to get into that in a little more depth because he's dealing with it on the ground with employers and helping them to take advantage of those tax credits as soon as possible. The other part here about group health plans and mandated testing coverage, just so you know, that really only relates to the health plan providers. Doesn't really have to do with you other than the fact that they're required to do testing and pay for that. And that's as far as it goes. It doesn't pertain to the treatment or anything beyond testing. So anything involving testing, yes. Beyond that, no. The Emergency Family and Medical Leave Act, as you can see here again, applies to employers with fewer than 500 employees. That is different than the regular Family and Medical Leave Act, as you may know. Normally that is for employers with under 50 employees. So there are obviously distinct differences between the regular Family Medical Leave Act and this Emergency Family Medical Leave Act. If you could just back up, it obviously applies to all employees, part-time, full-time, who have been employed for 30 days or more. So again, for those of you who know the Family and Medical Leave Act, it's for employees who have been employed for the past year and with a minimum of 1,250 hours of employment. So quite a bit different, and obviously we're dealing with an emergency circumstance, so that's why they've done that. It's a 12-week benefit, if you will, but the employees are not paid for the first 2 weeks of it. Now, if the employee happens to have some other paid leave through their terms with their employer, they can, of course, take advantage of that. So if they had 10 paid leave days coming and they wish to take those 10 paid leave days before their emergency FMLA leave kicked in, they certainly could do that. Okay, let's go to the next slide. This, again, as I've alluded to, is for employees who are unable to work or telework because their child care provider is no longer available, or the child's school or place of care has been closed due to a public health emergency. And of course, when they say public health emergency, they're referring to COVID-19. So in a situation now where we have all of our schools closed, I mean, this applies. So basically any parent or person who is in need of taking care of their child right now under 18 is eligible for this leave. Now, if they have somebody else who can do it, another spouse, for example, or another relative or someone else who can provide that care, then of course, I mean, within reason, they are not eligible to take the leave. Of course, you know, you can certainly get into debates with employees about whether or not they are the essential one and they have to do it. So probably on a close call, you would want to go ahead and err in favor of allowing the employee to do that. There is somewhat of an exception for children over 18 years of age. That is for disabled children. So if you had a child over 18 years of age who their place where they normally would be getting their care, if you will, is closed or no longer available, then and the employee had to stay and take care of that child, even though they were over 18, they would still be eligible for this emergency FMLA. All right, next slide. Yes, and again, this is a total of 12 weeks, and it may be taken intermittently. This is different than the emergency paid leave relating to the COVID-19, people who are affected by COVID-19. Obviously, for people who are affected by COVID-19, you don't want them coming in to work for a couple days and then leaving and then coming back even though they have COVID-19. So that's kind of the logic behind that, even though, of course, a lot of people are working remotely right now. But the emergency family medical leave can be taken intermittently. So, let's just say maybe a couple of parents wanted to trade off and one could work for a week and then the other, spouse could work for a week. That's something that you could certainly do. Now, as you can see, the rate of pay has to be no less than 2/3 of what their regular rate of pay is for the number of hours they would normally be scheduled to work. So what that means is if you're dealing with a full-time employee, then that would be 40 hours per week. So they'd have a total maximum eligibility of 80 hours. No, not 80 hours. This would be for 10 weeks. So it'd be it would be, I guess, 40 times 10. So it'd be 400 hours. If they were a part-time employee, you're going to be basing that on what their average hours have been for the past 6 months, if they've been employed for 6 months or more. If they haven't been employed for 6 months or more, you're either going to use the time that they've already been employed or what their expectations were in terms of their work hours. So if you had somebody who maybe just had started and you were expecting them to work 20 hours a week, then of course you would base their compensation on 2/3 of what they would have made for 20 hours a week. Now, this sort of goes, I suppose, without saying, but maybe I should interject it here. If you have no work for the employee, or for whatever reason they are not capable of performing the work, either on-site or remotely, you're not required to give paid leave. You don't have to give paid leave just because somebody is out, even though you don't need them. And I'm sure we have a lot of employers in that situation right now where, because of the circumstances, some employees simply aren't needed. It has to be a prerequisite that you would need them, and they would be working if they could be working. Now, of course, again, you don't want to get cute with that and let somebody, not pay them the benefits, saying that you didn't really need them anyway. Don't do that lightly. Now, obviously, there are a lot of legitimate situations like that right now, but that's just something to keep in mind. It's something where you might want to ask somebody like me or Larry about that before making a call one way or the other. But somebody can't just, have a position where you don't really need them anymore and they get 10 weeks of paid leave just because they decided, hey, this looks like a good way for me to get 10 weeks more of pay. The reinstatement provisions for this, when people have been out on leave, are the same as they are under the Family and Medical Leave Act, of course, except for the fact that, again, this ordinarily wouldn't apply to employers of under 50. And so there are some exceptions for employers under 50. For example, if it would affect if the position has been eliminated or a position has been eliminated, you don't need to bring that person back. That's how it is normally under the FMLA, but there is a sort of a financial viability component to this that I think is a little bit different for employers under 50. If you just simply can't afford to bring somebody back, then you're going to be okay and not bringing them back. There are some other details to all of this that might be on the next slide here. Let me see. We'll go ahead and move to that slide. Yeah, this says that there's an exception for employers with fewer than 25 employees. Again, referring to the fact that if the job no longer exists, be caused by an economic downturn or other conditions, due to a public health emergency, you do not have to bring the employee back. So I'm not exactly clear right now whether this is something that applies. That would seem to me to apply always under the Family and Medical Leave Act, really, or essentially the same thing. So I'm not quite clear on that. I think ordinarily speaking, if you don't have a position, or you can't afford to bring somebody back, you don't have work for them, you're probably going to be fine, whether it's this Emergency Family Medical Leave Act or the ordinary Family and Medical Leave Act. But, we'll be looking at this more closely as time goes on to see really how much differently they are treating the small employers who normally aren't under the FMLA. As you can see, one of those pieces to the exception here is that you would obviously try to make a reasonable effort to bring the employee back if you can. For your rank and file employees, that should be an equivalent position. A position's essentially the same as what they had. If you had 2 employees that were out, both doing the same thing, you eliminated one position, but there was still another position available because for whatever reason, the other employee didn't come back. You can't just say, well, we don't have to bring you back because your position was eliminated, even though you have another that's just like it that's available. So I think common sense would tell you that, and you would probably have figured that out on your own. There's no retroactive application in any of this, so that if somebody happened to go out and come back before this went into effect on April 1st, that's really of no concern. It wasn't in effect. It doesn't apply to you. You don't need to worry about it. Healthcare providers and first responders may be excluded. I think in all likelihood they will be excluded as long as they're actually healthcare providers and first responders as is defined by this act, which is sort of the people you would normally expect: doctors, nurses, police officers, firemen. Those people are probably all going to be excluded. But if you are a healthcare provider and you have somebody in an administrative role, then they are probably not, they're not actually a healthcare provider themselves, then they're not going to be excluded. There is a waiver process apparently in the works for the 50 employees whose business viability is jeopardized. That's what I was kind of getting at before. To me, there seems to be a little bit of haziness here as to really what applies to employers under 50 right now because of the financial circumstances. But I'm sure we will be getting a little more clarity on that. We have some other resources, which I think I'll let Larry direct you to when his time comes here. And there's some really good information out there, and you can sort of track it yourself if you like from the Department of Labor. But before I turn it over, I think this is probably my last slide. I'm going to turn it over to Larry, but I did want to mention too, which is sort of why you may have noticed I'm not actually in a courtroom right now. I have my courtroom background on. That's sort of as a little reminder that you are all here, and we're all here today so that you don't end up in court. There is an attorney fee provision in this law. And for those of you who are used to dealing with, let's just say, for example, the Fair Labor Standards Act, where with overtime claims, you know that you may have forgotten 15 minutes for an employee, and if they're disgruntled and they leave, they may go find an enterprising attorney and they come and they sue you because the attorney can get an attorney fee. And while they're running up their fee and you're trying to work this out or explain to them that you really did pay them for the 15 minutes or they weren't entitled to the 15 minutes, the next, their fee is getting bigger and bigger. So there is an opportunity here, and probably there's nothing more beneficial I could tell you today than to be sure that if you're dealing with one of these situations, you get the calculation right on what you owe them. Because if it's just a little bit off, you could end up with a lawsuit. And again, unfortunately, there are enterprising attorneys out there who will look at this as an opportunity. Somebody, they're going to be looking for some way to bring some additional claims because of this. So take care of yourself, be careful, make sure you get it right. And as always, make sure you've got things documented, make sure there's a lot of clarity on these relationships, situations that you have with employees, you know, what's happening, when it's happening, what the understanding is, and all of those sort of basics. Obviously, I think that's it for me. I'm going to turn it over to Larry at this point, and of course, we'll be available to answer your questions at the end.
Great, thanks, Greg. Appreciate that, and we'll jump right into the emergency paid sick leave. To Greg's point earlier, we want to get through this as quickly as possible so that we can answer your questions. So emergency paid sick leave was part of the same act. As he mentioned, there were two different laws inside the same act, and it's designed to work hand in hand with the Emergency Family Medical Leave Act change. And that's why you see the first 2 weeks of that leave is unpaid, is because the Emergency Paid Sick Leave Act is going to pick it up. Again, this one applies to all employers with fewer than 500 employees. One difference, instead of having 30 days of tenure with your company before you're eligible, literally it's 1 hour. If the person has worked for you, they're eligible for emergency paid sick leave under the Act. We're going to go to the next one, please. So what leaves are covered? And this is probably the most tangled web that we run into. There are 6 different reasons that a person could be covered under the emergency paid sick leave, and the payment amounts vary for those reasons. So we'll take the first 3, which are all, for the most part, targeted directly at the individual, at the worker themselves. If they're quarantined or isolated due to a federal, state, or local quarantine order or act, then, you know, and they cannot telework, obviously, then again, there's nothing you can do. They're eligible for paid sick leave. When they've been advised by a healthcare provider to self-quarantine. And this is somebody that's gone in and either their physician, nurse practitioner, PA, whoever they saw at their doctor's office said, hey, either you have underlying conditions that you shouldn't be out, or gee whiz, it seems like maybe you have some of the symptoms, but we want you to quarantine. You're not running a fever. That seems to be one of the hot points. Then that individual would be sitting at home for, 14 days is kind of like the normal quarantine period right now. And they would be paid for that. And then finally, when you're experiencing symptoms of this disease and you're seeking medical diagnosis. So again, and that one's to say, hey, yeah, I don't feel good. I don't feel good is not a reason to take this paid sick leave. I'm running a fever. I've got a cough. I'm going to see my doctor to see if I can get tested. That's a reason to go see it. That's a reason to put this in place. And you have, at the employer, typically we're really careful about asking people about medical conditions and all those kind of things. This is probably the one time there's going to be exceptions to this. And just as a side note, the EEO, who governs discrimination, released a notice about 10 days ago. It says, hey, it's okay for employers to check employees' temperatures when they come to work. That's completely out of the norm for them. This whole situation is out of the norm for us. The last 3 reasons you can be covered for the emergency paid sick leave all surround somebody else. So if you're caring for an individual, or you've got an individual who's been advised to self-quarantine and you have to care for them. Care for them doesn't mean keep them company. Care for them means that they are not able to care for themselves. You need to be there so that daily life functions can be continued. Again, the definitions on this are pretty gray at this point in time. Obviously, this law has only been out there about 3.5 weeks, so we don't have any case law. And like Greg said, this is a time to probably be a little more lenient than trying to find a black and white line to walk down. And then reason number 5 is exactly the same thing as what the FMLA covers, which is caring for a minor under the age of 18 whose school place of care is closed due to COVID-19. So there's the first 2 weeks that aren't paid under the FMLA, are paid under the emergency paid sick leave. And then finally, when the employee is experiencing any other substantially similar conditions. I don't think you can get much more vague than that. However, I did see some notice that, quite honestly, the Department of Health and Human Services has not listed anything for what are substantially similar conditions. You know, I can imagine perhaps somebody that's got COPD perhaps might qualify, but they're not releasing anything, any specific melodies that an individual may have that could create that. So let's get into the details a little bit. The maximum coverage is 80 hours. So that's a full-time employee, a 40-hour-a-week employee for 2 weeks would get 80 hours, and that's what's extended to them. Part-time employees are going to be entitled to a paid sick leave amount equal to the number of hours they would typically work in that 2-week pay period. Lots of questions in there. Well, what if the employee hasn't worked for me for very long? Or in the case of somebody that's only worked for you for a day and now all of a sudden is out on paid sick leave, what do I do? Well, usually you made an agreement with that individual when they came aboard, you're going to work 24 hours a week or whatever it is. That's what you're going to use if you don't have historical data to determine what the average hours per week are for the individual. Employees who use the paid sick leave for their own illness, that was numbers 1, 2, and 3, are paid at their regular rate of pay. So if they're making $15 an hour, they get paid $15 an hour. That's pretty straightforward. And I don't know why that's not working. Hold on a second, I'm about to lose my computer. Sorry about that technical glitch. I guess it happens a little bit when you bounce back and forth between home and the office. And then in cases of 4, 5, and 6, those are paid at similar to the FMLA. They're paid at 2/3 of the employee's rate. So if they make $15 an hour, you would pay them at least at $10 an hour. The pay is capped in these cases for when it's on the employee's own behalf. They're taking the paid sick leave at $511 a day or $5,110 for the 2-week period. If they are taking it to care for somebody else or because somebody is not able to attend school and they cannot telework, then the cap is at, with FMLA, is at $200 a day and a maximum of $2,000 for the 2 weeks. So the total value, if you were to look at it for FMLA and paid sick leave for someone who is at home taking care of a child, could be up to $12,000. Some additional details. This statute does not supplant any existing state or local paid leave laws. I don't think we have a lot of those in this area to worry about. But in other states, other locales, there are paid sick leave mandates. So these would actually probably be in addition to. As an employer, you cannot require employees to use other paid leave first, PTO, vacation, or sick. This is actually the primary, not the secondary pay method. Does not carry forward to next year. So if you don't use your number of hours that are allocated based on the amount of time you work by December 31st of 2020, at this point in time, it's gone. It expires on December 31 of this year. And, again, we're hoping that's all true. This can all change in a moment's notice. To say these regulations have been moving fast, it would be an understatement. And finally, one of the key points, and this applies to the FMLA and to the paid sick leave, is if you have group health insurance, the individual is a part of that group health insurance, then you have to keep that insurance in place. The employee is still responsible for their contribution. So if they're paying $100 a month, they're still responsible for that $100 a month. That's up to you, you as the employer, you and the employee to come to an agreement in terms of how you're going to make those payments, whether it's, give me $100 out of your each check, or, give me $50 and we'll catch up when you come back to work. And there's a number of different situations that employees and employers are going to come to satisfy this requirement. Some exclusions, considerations. Again, no retroactive application. If an employee took time off for sick leave prior to April 1st, then it needs to be paid out under whatever bank they have available from their employer. It is not eligible to be paid out under this program. Healthcare providers and first responders may be excluded from reason number 5. Again, that's the child care piece. If they have they have the disease, they are being quarantined, or they're in diagnostic testing, then they can still take paid sick leave. The only one that they can be excluded from is reason number 5. And again, the waiver process for employers fewer than 50, it's like there's documentation out there. I'll talk about that a little bit when we get into kind of our cleanup slides here, but it doesn't tell you who to turn it into. So it's still a developmental piece. And paid sick leave can only be used for 1 2-week period. So if you go out today and you take your 2 weeks of sick leave because you're ostensibly caring for somebody else who is sick and you have to be there to take care of them, then you're done. If you come down with this particular disease in a month, you're not going to be able to take your 2 weeks of paid sick leave. There's one allocation of 2 weeks at regular hours per employee. There's not multiple. And I'll hit the tax credit and the other pieces very, very fast. So the payroll tax credit applies to payments made to employees under these 2 programs. It's capped at the dollar amounts that we talked about earlier per person. It's a dollar for dollar tax credit against the employer's portion of Social Security. I'm not seeing Medicare mentioned. I'm not seeing anything else mentioned, purely Social Security. So the 6.2%, if you are familiar with the percentages of taxes on the dollar. And if the amount that you pay out exceeds your tax liability, you're going to get a refund. You get refunds paid directly to the employer by the government. Again, that's probably something that's going to happen at the end of the quarter when you filed your quarterly taxes. There's not a whole lot of direction from that. I think we're probably going to get direction regarding how that's going to be managed from the IRS, not the Department of Labor. Most of what I've spent my time on has been Department of Labor issues. The health plan benefit mandate, it just basically they said, hey, effective immediately, which is the one part of this law that went into effect immediately, was that diagnostic testing for COVID-19 is 100% payable by your health insurance without any deductibles or copays. It does also say group plans. So if you have individual coverage, I'm not sure how that works. I would check with your agent. Perhaps they could guide you through that. Some of the covered services could be doctor's visits, ER visits, or urgent care, anything that's leading to the decision that you need to be tested for COVID-19 and the testing itself. If you've been confirmed positive, this does not cover the treatment. So if you end up in the hospital for a period of time or have prescriptions that your physician asks you to take and related to it, those are not covered at the 100%. They would fall underneath of whatever your normal conditions are for your health insurance plan. And again, this went into effect immediately. So kind of wrap up a few things real quickly so we can get some questions. The Department of Labor did issue a poster which has to be provided for all employees. I put the link on the slide. You can click it right to it. It's a nice little 8.5 by 11 PDF that you can download and email. With a lot of employees working remote, emailing it to them is absolutely acceptable. You don't want them to come into their office so they can see a poster. If you do have folks in your office, then you want to print one out and put it on the bulletin board where you have your normal employment posters. Probably one of the better sources of data I have seen, and quite honestly, I take it as being my ultimate guide, is the Wage and Hour Department has created an FAQ on their website. Again, the link is there on the slide, which started out with about 15 questions the first week or so after the law was passed. It's up to 79, and they continue to add and edit as they go. It's a very good piece. It answers a lot of questions, a lot more detail than we're able to go into, quite honestly, on a webinar. So what happens if your business is temporarily closed or you have no work? To Greg's point, if you closed your business the 30th, I mean, we know a lot of restaurants did. They didn't want to do takeout, or were not set up to do takeout, whatever it is. You're not required to make any payments under this. Obviously, if you have a hotel or something else, you're probably going to have 1 or 2 employees around as security or maintenance just to make sure that things are taken care of. You still aren't collecting revenue, so you're technically your business is still closed. if you don't have work, again, if you have a large restaurant, you've gone down to takeout. Instead of having 30, 40, 50 people on a shift, you need 8. Well, that's what you have. I mean, the other folks you don't have work for. So again, technically they would not be subject to these programs. And the biggest part about the programs is if you have somebody in that situation and you make payments to them anyway, because you're trying to be a good employer, you're trying to keep your employees happy, then unfortunately you're not going to get the tax credit for it if they don't have a qualifying reason. You want to track everything. I mean, one of the things, probably your HR person, your attorney, whoever you talk to, says track everything. And on the next slide, my first line, I'm quite honestly, I'm going to just reemphasize the same thing: document, document, document. Probably every HR session you've ever gone to, we say the same thing. There are pretty good documentation rules, again, in that FAQ regarding what you need to document for someone based upon the different reasons they're taking the leave. And those have been edited literally over the weekend to include a little more information about getting the name of the school, what grade they're in, all those kind of things, so that if it comes back to at some point, if you get audited and somebody says, well, let's see why you're claiming this tax credit, well, here's my documentation. You're going to want to have that. Any weeks of the EFMLA that are used now will count toward your traditional FMLA allotment of 12 weeks in the next year. So basically, the way FMLA works, you have a 12-month rolling period where you look at people taking leave. If somebody has already taken FMLA for, let's say, a surgical procedure in January, and then took 4 weeks, if they took those 4 weeks, their amount of emergency family medical leave that's available to them is 8 weeks. You only get 12 weeks in a given 12-month period. What happens if you're close to 500 employees? Well, the way the law is written is the employee count is based on the day the request for leave is submitted. So let's say last week you had 505 employees, but during the week last week, 10 people quit. Now you're under 500 and somebody applies for paid sick leave today. They would be eligible because you're under 500 employees. So it's really day specific for your head count. I know that's really tough to manage. If you're right at that 500 number, that's a tough animal. And the 30-day compliance window that Greg mentioned earlier, that runs out this week. It's the 17th. So, if you think you've maybe made some errors or whatever, this is kind of your time to clean it up. And quite honestly, if you clean it up next week, they're going to be happy with you. They just don't want they want people to get a chance to at least understand what was happening before the wage and hour decided to start doing investigations. And quite honestly, their investigations are going to be difficult to conduct at this point in time as well. But you just want to this is the time to be a little more lenient with your employees, a time to think thoughtfully. If you have questions on legal matters, reach out to your attorney. Reach out, if it's, hey, how am I going to apply this internally? Reach out to your HR professional that you have in-house. If not, we've been doing that for a number of clients here for quite a period of time, and quite honestly, the last month has been hectic. If somebody has a question, I'll probably take a shot and try and answer it for you. So, you can always reach out to me, and if nothing else, maybe I can refer you to somebody else if it turns out to be a legal question. So that's all I have. We'll be ready for some questions.
All right, very good. Gentlemen, thank you very much for sharing that expertise. I know this is kind of a changing on the fly kind of topic, so we'll get to a few questions that came up throughout the session. For those of you who are with us, if you have additional questions, add them into the bottom of the chat box and we'll work through as many as we can get to. I think first question is probably for Greg, because I think it goes to the business viability question. What concern they got a notice from their HR provider handling their payroll, and concern was obviously FMLA is generally unpaid. what if the employer cannot afford to pay them after the first 2 weeks? How does that work? And I think that probably goes to the viability of the business question you were saying in the Act Reg. Is that correct?
Yes. I think that if you legitimately have financial issues and you can't afford to pay leave or the emergency FMLA benefits for the child care, you're going to be okay. The key here is to salvage the business. And so if it's legitimate and you can document it and just show that, you're doing the best you can, you're being reasonable, I think you're going to be fine. I did want to add one thing. I think Larry picked up on this, but I wasn't very clear about the fact that the cap on the Emergency Family Medical Leave Act benefits is $200 a day. So those wage calculations matter, but the maximum is going to be $200 a day. And of course, that would translate to $10,000 over the full 10 weeks. So anyway, I just wanted to clarify that so there wasn't confusion.
All right, thank you. Another question is someone has an exempt salary employee who takes 1 day off a week for a child being out of school. Do they have to pay the full weekly salary or 2/3 of his pay for the days he is not at work? So it seems like he's perhaps voluntarily or is needing to take reduced hours. How does that apply in the Act?
Larry, do you want to take that one? Or do you want
Sure.
me to?
Yeah, I mean, in essence, what you're talking about is an intermittent use. Is for the child care piece, and again, the FAQ that the link on the slide has really talks into co-parenting. There's two people, they have one child, one of them can work Monday, Wednesday, Friday from home, the other one's working Tuesday and Thursday from home. Between them, they can take care of the child, but they're going to have a couple of days off a week. That's exactly what this is for. So you would pay the employee would get 1 day of paid sick leave that they would utilize in that given week, and then 4 days at their regular rate. It doesn't change their exemption status. All we're doing is saying, hey, you're not working. Typically, I'd probably ask you to pay, use your PTO, and you don't have to use PTO. You can use paid sick leave or emergency family medical leave.
Okay, very good. Let me get, there was a couple of questions that I was chatting, and I want to make sure I'm following the thread correctly here. And I think we asked the first part. They were saying that emergency FLA, the first 2 weeks are unpaid, but the employee rights poster says we're paid up to 80 hours. So I think that is the overlap of the paid sick leave emergency and the FMLA, correct? So the paid sick leave would be what would apply there. Am I understanding that correctly?
Yes.
Well,
Okay.
the only reason, of course, that would apply would be if someone is actually either affected by COVID-19 or caring for someone who's affected by COVID-19. And there, we didn't get into the details on that, but there are there's some guidance on who that is. If it's somebody living in your household, yes, you're caring for that. That person qualifies. If but if they're not living in your household, then it's going to be a matter of, would the expectation be that you would be taking care of that person? Let's just say you had an elderly parent who lived in the area and they have nobody else to care for them. The reasonable expectation would probably be, the child is going to care for the parent. They would qualify. But in any event, we didn't get into all those details, but there's some guidance on that if you have a question.
Okay. All right. Very good. Next question. We were talking about the employee's average rate of pay, and there was a question about their understanding was that you pay an employee an average rate, which can include overtime, not just their regular rate. Is that accurate in terms of if it's like a regular occurrence that would be part of their pay on a normal basis?
You're going to count the hours. So if an employee averages 45 hours a week because they typically have 5 hours of overtime every week, you would look at the 45 hours. The regular rate of pay is the regular rate of pay. I don't see where you have to do a blended rate of pay, taking in the overtime dollars. And I didn't understand it that way. From what I've read, again, there's a lot of things here that are pretty gray. But if you have an employee, let's say, that does work 45 hours a week, they're still only allocated 80 hours of paid sick leave. So maybe you pay them 45 hours the first week and 35 the second week. Because this is leave time, it's not subject to overtime rules. It's like any other thing. If you're not working, overtime does not apply. It would just be purely paid those 45 hours at either your regular rate or 2/3 the rate, depending on the reason the individual is taking the time off. That's my understanding.
I agree with that. I think you're going to be your regular rate of pay. And remember, too, that this is over a 6-month period. And so if somebody came in at one rate 6 months ago and they've gone up, you're going to take the average rate, regular rate for that period of time. So it may be somewhat less than their current rate. They may not like that, but that is, I think, what the law is.
All right. If there are any last questions from our audience, we'll give you a few seconds to submit those via the chat. While we're giving folks a minute to see if they've got any last minute questions, I want to ask each of you real quick, if you could share what is the most common question or issue that you're dealing with as clients have reached out to you. What are they most commonly asking? Because I would be willing to bet if there is a commonality, probably some of our attendees are experiencing that as well.
Why don't you start, Larry? You're probably getting deluged a little more than I am on this.
Yeah, I would say the biggest thing I hear clients ask is, what can I require for documentation that their school's closed? What kind of documentation do you need? And that's been very slow in developing. Like I said, I went back and read the FAQ again yesterday. I read it every week, and they had started adjusting things like that, saying if somebody's taking paid sick leave and/or EFMLA to take care of a minor child, here's the reasons they can do it, and here's what you need to document. I think that's number one. I think number two is, can you tell me what an employee rate of pay should be? And it's like, yeah, I mean, it's to Greg's point, you just have to go back and it's a little bit of math. It's not terrible. Well, what's that person's average hourly rate? I would caution folks who just want to take the number of hours they work and reduce it to 2/3 and not adjust the hourly rate of pay, because the law is actually written and it's 2/3 of their rate of pay. And the last thing you do is want to create data that is confusing for someone that may be looking at it down the road to determine if you're in compliance.
All right, we have one final question that was submitted, and we'll close it out after this. With regard to the restaurant industry, how do we calculate what to pay a tipped employee who has not worked because they did not want to work in a restaurant with less than 50 employees for fear of contracting COVID-19 or the coronavirus?
And that's maybe kind of two different questions there.
Exactly.
I don't think there is an exception for people who don't want to take a chance when they're working. If their excuse for not coming in is simply they don't want to be exposed, then I don't think they qualify for anything. They've chosen not to work. That's a voluntary decision on their part. I believe, and Larry, you tell me if you think I'm wrong, but I think if you did have someone like that who did qualify, and they were normally a tipped employee, I think you go to minimum wage. And remember, in Florida, we have an extra $1 tacked on to the federal minimum wage. So you would be using that figure, I believe. You agree with that, Larry?
Yeah, and again, and restaurants are always difficult. Absolutely agree with what you said in the first part, saying I'm not coming to work because I don't want to catch it, unless your place of employment, unfortunately, like the meatpacking plant in South Dakota, where literally 1/3 of the employees came down with it. That's a different story. That's a hot spot. But just because you don't want to come to work doesn't apply. Yeah, and again, the answers have been fairly gray. One time I read that it should include whatever their normal hourly rate of pay is, plus their commissions, plus tips, all those kind of things. I would say before you start jumping down that road, if we take a look at the FAQ, if somebody wants to call me and and talk about that piece, I'll definitely do it. But to Greg's point, you're definitely going to have to base yourself at least at minimum wage, which in the state of Florida is something above the 725 that it is federally. But again, there's a lot of moving parts here that every situation is different, and trying to throw a blanket over it, I think, is a mistake.
And I'll just add before we adjourn that, like Larry, if you have a question, don't hesitate to contact me. You can consider it a perk of membership in the Chamber of Commerce. I'm not going to charge you if it's a simple question. I just want to make sure that to the extent we can, we help our business people out there. I'd much rather, I know you might be skeptical because I make my living representing people who have problems, but I would much rather you actually avoid the problem and never have to come to see me and say, look, I messed up. I wish I had known. Now I've got a problem.
I think the problems exist to the extent that will keep you sufficiently in your line of work. We don't want to create more and overwhelm you.
I've got lots to do, and some things that aren't problems too. Some things we're helping just to build businesses, of course, but I'm easy to find. My email address is gsnell at snell-legal.law. But again, with a quick Google search, you can find me, email me, call me, if you need me. And I'll try to be help to you, even if it means sending you somewhere else.
Well, we had requests for some of the links that Larry had included in his presentation. So I committed to emailing those to all of the attendees today. So with your guys' permission, I'll include your email addresses in that email so that they have easy access for that. So
no problem.
Can't thank you guys enough for being willing to go out on a limb. When you are in a position of expertise, but the information is changing, I can imagine it's a little uncertain ground that you're walking. So we really appreciate you helping us out, helping our members out, trying to provide as good information as possible. Thank you so much for your time, talent, and expertise today.
My pleasure.
My pleasure. And this is the time no one needs to walk alone. Find somebody you can ask the questions to, rather than just kind of wandering off in the dark.
Well said, Larry. Just a couple of notes on things coming up for our attendees. We have a session with Congressman Michael Waltz coming up tomorrow. If you're interested in hearing some more about what's happening in Washington, D.C. and opportunities to provide stories, input, suggestions to the Congressman, you can email those to Jim Cameron in the Chamber office, jim@DaytonaChamber.com. He'll be taking those questions. That's coming up tomorrow, April 16th. And then next Tuesday, even though we can't gather in person as we've been doing all our sessions remotely like this one, we have coming up a virtual networking opportunity. Let's Connect on Facebook Live. Just go to the Daytona Regional Chamber Facebook page at 4 o'clock on Tuesday, April 24th, and we'll be gathering and connecting and building relationships, even if we have to do it virtually and at a safe distance. So with that, thank you everyone for attending. Greg and Larry, thank you once again, and we'll see you at the next virtual program. So long, everybody.
Stay safe.